So the first thing we're going to look at is the core duties of directors. Now, this is more complex than what we're going to deal with, but what I want us to be able to leave this course with is an idea of the fundamental requirements when we're a director or an officer. We're in those leading positions in companies. So that's why I'm going to call it this core area of duties. As we mentioned just before, there's a few steps to that. In this little video, we're going to look at why we have directors, who those directors can be, and then who they owe their duty to. Once we know that, we can move on to understanding what those core duties might be. So why don't we get into it and have a look at why we actually have directors. So what you may remember from that wonderful subject GSN 412, business law, is that the law has established that companies and corporations generally are separate legal entities, separate legal persons for the law. That means they can own property, they can sue and be sued, they can enter contracts. And that came from that wonderful case of Salomon and Salomon, which I won't bore you with the details, including the great cobblers' strike of the 1890s that led to the case. But in any sense, that case started this idea that companies are separate from their owners and from their shareholders. So the core attribute of the corporation is this separation of the legal entity from its shareholders or owners or any other parties, which starts to raise a bit of a problem, right? The problem then becomes, well, who gets to make the decisions for this separate legal entity? Because really corporations can't make decisions, only people can. So who are the people who are going to make decisions? And just as importantly, if we limit liability so that the shareholders won't be liable for the actions of the company, and that's one of the great advantages of the corporation, right? If we do that, then who are we going to hold to account if something goes wrong? And how are we going to hold them to account? And so this is where this idea of directors and officers' duties springs from. It answers these two core questions. Now, while the answers to these questions can vary from company to company, what we've got on this slide is the general or vanilla position around power in the company, right? So in the Corporations Act, this is a replaceable rule. What that means is it's the rule that is put in a company's constitution unless it's taken out and replaced. And so the general rule that governs who can make decisions for companies is this one. The business of the company is to be managed by or under the direction of the directors. Okay. So what that means is that all power to run the company is with the board. Okay. So management don't have any power. They only have powers that are delegated from the board. Now, as I said, you need to check your constitution because sometimes when a company comes together, we can see that they have different rules. These rules are actually what's known as the constitution of the company, right? So that constitution is like this set of interlocking powers. It's called a statutory contract. So one of the legal ways of thinking about a company is that it's all these contracts that are melding together, and a core one is the Constitution, and it sets out the respective rights and powers. So another power in the Constitution is that the shareholders generally get to appoint and dismiss the directors, right? So that's where their power comes from. They can't actually tell the company to do anything, but they can remove the directors if they don't like what they're doing. Okay. So the Constitution is core. Sometimes in certain organisations, often not-for-profits with a religious base or maybe a government-owned corporation, they might say that the board can't do a couple of things. Like it's not uncommon that the CEO has to be appointed by the members or by the minister if you're a corporation. And there's less and less of that, but it hasn't been an uncommon prescription. So what you can see is that this general rule applies most of the time, but you really need to be sure to check your constitution to know what the powers of the board actually are. So we have these powers which are given to the directors. The next thing we've got to work out is who actually is a director. Now, this might sound a bit obvious because, of course, it will include those people who are validly appointed. But one of the things that the law's a bit worried about, right, is what happens if you have a kind of a puppet company. Because we have this separate legal entity, what happens if you have someone who's guiding the company but isn't a director? If they're only a shareholder, well, then they're not going to be liable, are they? Well, this is where the law comes in, and it talks about shadow directors, and it also talks about de facto directors. Okay, so what this means is if you act like a director, or if you actually control the directors, you will be held to be a director. So it's beyond those who are validly appointed. Okay. Now, I don't want to overemphasize this point too much. It's actually quite difficult to make out that someone is a shadow or a shadow director, okay, or a de facto director. Either they would, you might remember from agency law, it's kind of this ostensible authority deal is the de facto director. So if you act like it and people think you are a director, then you'll be liable as if you are. The second case, the shadow director, the courts will at certain times think that, well, really there's this one individual who owns all the shares and are telling everyone what to do. So if you can show evidence that the board does whatever that person says, okay, then they can be held to be a shadow director. Pretty hard to make out, but it's trying to overcome those problems when people are trying to control a company without being liable. We've worked out the powers and why we have companies, and we've also then thought about, well, who actually is a director, who's going to be liable. So the a third component for us to think about is, well, who do the directors owe their duties to? Because what we're going to put is this proposition, right? That directors have to act in a certain way, that they owe a duty. Okay. But who do they owe it to? And this can be a reasonably complex answer depending upon your frame of reference. It depends upon, for instance, your jurisdiction. So in the UK, right, it's embedded into their Corporations Act that directors owe a duty to employees. In Californian law, I think that there's a provision that you have to look at society, and some could argue it's also embedded into German law. In Australia, though, it's very clear. Directors don't owe a positive duty to any of these groups, to anyone in particular. They owe their duty to the company as a whole. So they owe their duty to this separate legal entity. Well, then the question becomes, how do you work out what that is? And isn't that just the shareholders or the shareholders' interests? And 2 points about this. Look, in reality, most of the time, if you look after the shareholders as a group, then you will be looking after the company as a whole. However, from time to time, right, the interests of the company might vary from the shareholders. Okay, so one of those times is as you approach insolvency. Right? As you approach insolvency, shareholders and members probably want you to take greater risk to try and keep some of their money, but the creditors don't want you to. Okay, so one of the things is as you approach insolvency, the interests of creditors tend to rise. Okay, so this is a complex thing. So the interests of the company become more aligned with the creditors because that's going to give long-term survival to the company than the interests of the shareholders who want a risk-reward trade-off, right? It's a different kind of decision-making. So what you see is as you start to approach insolvency, how you determine what the interests of the company as a whole are starts to shift the focus more on the creditors. So that's one example, right? A very clear example in the law. Bear in mind, you do not owe creditors, right, a separate legal duty. The Crown and Spies, for instance, is one of those cases that shows that. But the interests of the company become more aligned with the creditors. In much the same way, there was a famous example in James Hardy about, do you just owe your duty to maximising shareholder wealth? It all had to do with the actions, which were quite legal at the time, that they took to rid themselves of their liabilities for the harms caused by their mining of asbestos, right? So I'm pretty sure you'll be familiar with that. If not, look it up. It's worth getting an understanding. And so what they did was essentially set up a different company to put the liability in and then funded that. Then the company moved offshore to the Netherlands, ostensibly for taxation reasons. And as part of that shift, they then severed liability through to this company that funded the asbestos related harms that had been caused. And of course, it was woefully underfunded. Well, there was a big hoopla, particularly in New South Wales, and the directors of James Hardie were arguing, well, look, what we did was entirely legal, and we are under a duty to look after our shareholders to maximise shareholder wealth. So the Parliament, the federal Parliament who looks after the Corporations Act now, thought about this and said, well, if this is true, we might need to change the law. So they had a couple of commissions, as governments do. They had a joint parliamentary commission to look at it, and I think the Corporates and Markets Advisory Commission had a look into this. Both of them came back and said, look, no, you owe your company to a duty, which is like owing it to current and future shareholders. That's a really important distinction, right? It's got a long-term view. You can also don't have to solely focus on the interests of shareholders, particularly in the short term, right? Particularly maximising shareholder wealth. So you can take the interests of stakeholders into account if you think it's good for the long-term viability of the company. So that's a really important distinction, right? You're not bound to just maximise short-term wealth. It's all about the long-term sustainability of the corporation. So just to summarise where we've come to, right? Why do we have directors and officers? Well, companies are separate legal entities. Someone's got to be able to guide them or make their decisions. That is generally vested in the board of directors. Also, someone needs to be held to account when things don't go wrong, right? So we're going to work out how that gets done when we speak about the duties in particular. But what the law does is impose duties on those decision makers, on the directors and officers. We then looked at, well, then who is a director? And we found that the law has in place, of course, those who are validly appointed, but it can also extend to others who might be influencing the corporation. And then finally, we looked at who do we actually owe this duty to? And we saw that we owe the duty to the company as a whole. Generally, that's going to mean shareholders as a group, but at various specific times, it can mean broader than just shareholders, for instance, creditors as you approach insolvency. And it also allows you to take the interests of stakeholders into account when you make decisions, if that's going to be in the long-term interests of the company, but you don't owe any of them a specific duty. So we've talked about who can make decisions, what those decisions are, basically every decision, and who we owe a duty to. Next, we're going to look at what those duties actually are.